afternoon, Prof. We are from Group 2 members that will be presenting Chapter 2 Legal Aspects in Human Resource Management. And there are 3 parts in this chapter. So the first part will be presented by me, which is Tan Xing Zhu, matrix number 277878. Second part will be Yang Shu Kim, 276831. And the last part will be presented by Yong Xin 278322. The learning objective of Chapter 2, Part 1 will be, at the end of this chapter, you should be able to discuss various labor laws in Malaysia. Introduction. The compliance of labor law by the organization can enhance motivation and morale of employees because they will feel that there is justice in the organization where their rights are protected. Non-compliance with the stipulated rules and regulations will have a serious impact on the organization businesses because the organization may have to face illegal allegations. Employment Act 1955. It is administered and enforced by the Department of Labour Peninsular Malaysia, which contains provision on the minimum standards for setting terms and conditions of employment of employees in the private sector located within the states of Peninsular Malaysia and Territory of Sabah. The Employment Act 1955 only covers and protects private sector employees whose salary is not more than 2,000 per month, and the contract employee whose wages exceed 2,000 ringgit but not exceed 5,000 ringgit, and those who work as manual laborers, supervise manual laborers, operate or maintain mechanically propelled vehicles, or domestic servants irrespective of their monthly wages. And the last one will be foreign workers, part-timers, temporary or fixed-term contract employees as long as they satisfy the criteria 1 and 2. And the major aim of this act is to set minimum labor standards for employees and to protect them from exploitation. Next, the main areas covered by the Employment Act 1955. The first one will be contract of service, and it is an agreement when a person agrees to employ another person as an employee and that other person agrees to serve as an employee. This contract of service can be in an oral or written form and also can be expressed or implied. For employees who are covered by a valid collective agreement that is signed between the employer and its union, the terms and conditions as stipulated if the collective agreement will apply. And what to include in the contract of service? Basically, they will be employee's name and number of identity card, type of employment and position, wages rate, period of wages, other allowance, incentive payable, and payment rate, other additional benefits, normal hours of work per day, overtime rate, and the number of days entitled for annual leave, public holidays, medical and hospitalization leave, and other leaves with pay, the period of notice for termination of wages in lieu of notice as agreed, and the last one will be retrenchment benefits. And from the doctor's tip, it is safer to have your contract of service in a written form. And the second main areas that is covered under the Employment Act 1955 is the payment of wages. The Employment Act 1955 had defined wages as basic wages and all other payments in cash payable to an employee for work done in respect of his or her contract of service. However, the wages do not include the following: the house accommodation, any contribution paid, any other fund or scheme established for the benefit or welfare of the employee, any traveling allowance, any sum payable to the employee, any gratuity payable on discharge or retirement, and the last one will be any annual bonus or any part of any annual bonus. And the important thing will be the wages of an employee can be calculated based on monthly, weekly, daily, hourly, or piece rate basis. An employee's wage must be paid at least once a month. The payment of wages must be made not later than 7 days after The payment of wages must be made not later than 7 days after the end of the wage period. The employer shall issue a statement to an employee to show the details of wages, allowance earned, and lawful deduction during the wage period. Example of salary slip here. Next will be the employment of women. Employers should not request their female employees to work between the hours of 10 o'clock in the evening and 5 o'clock in the morning. A female employee must be given a rest of at least 11 hours before commencing work for the day. Female employees are not allowed to be employed for any underground work and the maternity leave and allowance. Female employees are entitled to maternity leave and allowance for a period of not less than 60 consecutive days of each birth. The female employees are allowed to take 14 days earlier than the date originally determined if certified by a registered medical practitioner. A female employee, irrespective of her wages and position, shall be entitled to receive maternity allowance for the eligible period from her employer if she has been employed at any time in the 4 months prior to her confinement, or she has worked for a period of 90 days during the 9 months before her confinement. A female employee must, within a period of 60 days before her confinement, informs her employer regarding her pregnancy and the date from which she intends to start her maternity leave. The maternity allowance can be suspended by the employer if the female employee failure to notify it to the employer. A female employee shall not entitled to any maternity allowance if at the time of her confinement she has 5 or more surviving children. Confinement is defined as giving birth after at least 22 weeks of pregnancy, irrespective of whether the baby is born dead or alive. And the next one that covered by the Employment Act will be the working hours and holidays. Section 60A of the Employment Act 1995 has restricted the rights of the employer to require its employees to work more than 5 consecutive hours without a period of rest of not less than 30 minutes duration. And next will be more than 8 hours per day, more than 48 hours per week, and lastly in excess of a spread over period of 10 hours in one day. And every employee is also entitled to have 11 paid public holidays. The 5 public holidays which are compulsory to be granted to the employees are National Day, Malaysia Day, Labor Day, Yang di-Pertuan Agong's birthday, and lastly will be the birthday of the Sultan or the governor of the state where the employee mainly works. These 5 paid public holidays cannot be substituted for another day or other types of holiday. The remaining 6 paid public holidays can be selected by the employer or be substituted to other days with the agreement between the employer and the employee. And when an employee works beyond normal hours of work in a day, he or she is entitled to claim for overtime pay. The limit of overtime work should be a total of 104 hours in any one month, which should exclude overtime hours on the rest day and public holidays. And every employee is also entitled to paid annual leave. An employee is not entitled to annual leave if his or her absenteeism exceeds 10% of the working days during the 12 months of his or her entitlement to annual leave. Every employee is entitled for 60 days of hospitalization leave irrespective of his or her years of service within an organization. And the last one will be registers, returns, complaints, and inquiries. The book of registration must be updated within 3 days after the end of each wage period and kept in the office of the organization where the employees are employed. And the Employment Act 1955 also outlines the provision of employees' reinstatement due to constructive dismissal, employees' grievance, and domestic inquiry.
Minimum Wages Order 2020, effective from 1st July 2016. Minimum wages is defined as basic wages. The minimum wages rate payable to an employee shall be not less than 1,000 ringgit per month for the employees who work at Peninsular Malaysia, 920 per month for the employees who work at Sabah, Sarawak and the Federal Territory of Laban. Minimum retirement age at 2012, effective from 1st July 2013, is compulsory for all employers in Malaysia who employ employees regardless of the amount of salary paid to fix the minimum retirement age of an employee as 60 years. An employer must not prematurely retire an employee before the employee attains the minimum retirement age. An employee must choose for early retirement once he or she attains the age of optional retirement as agreed in the contract of service or collective agreement. Children and Young Persons Employment Act 1966. This act regulates the employment of children and young people and young persons to give them rights and protection from mistreatment in the course of their employment, effective from 1st March 2011. For a child, only light work in family's business, public entertainment, not more than 6 hours in any day, not more than 6 days in 1 week. For the young person, in light work that does not involve the use of machinery, maximum of 7 hours per day, may not work between 8 p.m. until 6 a.m., not more than 4 consecutive hours without a period of rest. Workers' Minimum Standards of Housing and Amenities Act 1919. The objective of this act is to monitor and control the minimum quality of housing facilities and other social amenities provided by the employer to the employees. If the employees are provided with housing at their place of employment, the employers have a responsibility to provide a clean and good condition of house, adequate electricity supply, allotting 250 square meters of the land to an employee who has been employed for a minimum period of 6 months for cultivation and grazing purposes. Payments for medical treatments. Workmen's Compensation Act 1952, effective from 1st July 1992. The objective of this act is to provide compensation payment to foreign workers who have accidents at work or who contract employment-related diseases. The employer is not allowed to deduct the earnings of an employee for the payment of insurance premium. Employees' Social Security Act 1969 provide protection to employees who may be involved in an accident at work or who contract some occupational disease. The registration of social is based on the principle of once in, always in. Social provide coverage to eligible employees through social protection schemes, employment insurance schemes, invalidity pension schemes. There are 2 categories schemes. First category. This category consists of employment insurance schemes and invalidity pension schemes. Only covers employees below 60 years of age. The contribution is paid by both the employer and the employee. Second category. only consists of employment insurance schemes, protects employees above 60 years of age and still working. Employees above 55 years of age when first registered and contribute of social. Employees Provident Fund Act 1991. The main objective of this act is to ensure that employees have funds available after their retirement. This act covers four categories of employees: all local private sector employees who are employed by an employer under a contract of service or apprenticeship, non-pensionable public sector employees, expatriates and foreign workers who earn less than 2,500 per month, those who have the contribute before 1st August 1998.
Hi, good day to doctor and classmate. My name is Yong Lee and my matric number is 278322. Now let us continue with the last part of chapter 2, Legend Aspect in Human Resource Management. First, I want to present is Trade Union Act 1959. In Malay, we can call it Akta Kesatuan Sekerja 1959. This act has required the procedure of applying of registration of an union, the use of union fund, the right and liability of unions, and other matters relating to the constitution of union. So, all trade union must request to be registered and certified as qualified union under this law in order to respect its members in trade dispute. So the next is, this act has stipulated that all employees who are anyone over the age of 16 who has not yet reached the age of 21 have the right to enter a certified trade union. He or she is not, however, qualified to serve a union officer. So the next is, an individual who has not reached the age of 19 is unable to vote on issues such as the lockout, living in position, union dissolution, and modification of trade union law. Besides that, the act has also regulated that the officer of a trade union should be Malaysian citizen. He or she must have worked in a reconciled union for at least 1 year. Third is never have been a member of an executive board of a union that was dissolved or disbanded. So this is most important. If you ban it, so we cannot enter again. So the next is, he or she is not a member of political party as an officer or employee. Besides that, he or she should not be convicted of a crime. Last, he or she also cannot be a bankrupt person. So this is all of the Trade Union Act 1959. If you want to learn more about this act, you can go to this website to search out more related information about this. Next, let us see what is Industrial Relation Act 1967. Industrial Relation Act 1967 in Malay is called Akta Perhubungan Perusahaan 1967. It is regulated the relationship between employer and employee or between employee and their trade union, as well as the prevention of restoration of trade issue. So that this act main goal is to encourage harmonious relations between worker and employer by allowing them to resolve their different terms without discussion with minimum government action. This law provides of the following provision. First, the legend right of employer and their unions. Next is procedure related to the request of recommendation, the scope and representation of trade unions and collective bargaining. Besides that, proposal involving collective bargaining shall not include matters such as employee promotion, internal transfer, employee recruitment, dismissal, layoff, and reinstatement and assignment of duty related to any of above methods. Furthermore, procedures of the settlement of trade disputed. Last but not least, the Human Resource Department has the power to intervene and submit any trade disputed to the Industrial Court for arbitration. Next is the regulated that the employer is not permitted to do the following: set any condition in the contract of service retirement, the right of an employee to join a trade union, induce an employee not to join trade unions by offering certain advantages, and so on. So that the act also imposes that an employee and their trade union is not permitted to do the following: pressure as employee to join the trade union during the working time except when permitted by the employer, treated or injured any person to be or not to be a member or officer of the trade union, induce an employee or officer of the trade union by offering certain advantages. So now we look at the next act is Occupation Safety and Healthy Act 1994. So in Malay, we can call it Akta Keselamatan dan Kesehatan Pekerjaan 1994. The Occupation Safety and Healthy Act 1994 provides the legislative framework of the safety, healthy, and welfare among Malaysian workforce. The principle is to prevent and protect the workers against harmness and it based in combination with their activity at work. The purpose of this policy is to raise up safety and healthy awareness while also encouraging success, safety, and healthy performance through self-regulation schemes tailored to the need of each organization. Okay, next is three main principles that have been taken as the foundation in the drafting of this act is SCC, which is self-regulation, consultation, and cooperation. First, self-regulation is required all companies to ensure and document such as safety and healthy policy, duty of employer, employee, and the safety healthy officer. The third is the safety and healthy committed of company. And number four is occupation safety and healthy inspection of inpatient and officer, and so on. Next is consultation. These principles all related people in company must discuss to resolve issue and problem relating to workplace safety and health. Last principle is cooperation. Employer and employee must cooperate to upgrade the standard of safety and healthy at workplace. If employer with more than 5 employees must create a systematic safety and healthy policy according to the act and must be included general policy statement, organization, and arrangement. So, okay, continue with employer responsibility under the act are as follows: maintain a safe and healthy working environment, including the work system, ensure that the use, operation, handling, store, and transport staff equipment are safe. Ensure that the correct safety information, instruction, training, and supervision are available. So the next, ensure that the work environment as well as the means of the way enter to act are safe. The last one of the duty employer is provide suitable facility of employee well-being. Not only employer need to take responsibility to avoid emergency happen. An employee general responsibility may include the following, which is that proper treatment of his or her own safety and health, as well as the safety and health of others who may be injured by his or her task. So the second is cooperate with employer or other individuals in carrying out the act and safety regulation responsibility. So the third one is wear or use personal protective equipment and clothes supplied by the employer at all the time. So I give an example. The contractor must wear a set of healthy helmet before entering the construction site. This is the normal. We can see the employee follow the rules before enter the work environment. That personally is follow all occupation safety and health regulation in induction and measurement. So this coming to end, the last end of this chapter is Pembangunan Sumber Manusia Berhad Act 2001. Short name is PSMB Act 2001. Before that, it is called in Human Resource Development Act 1992. This end of this act is to encourage employers to conduct training of their workers so as to upgrade their skill and ability through the imposition and collect of a human resource development levy. Furthermore, the human resource development levy is the mandatory levy payment and inserted under the legend requirement of the PSMB Act 2001. It is called Human Resource Development Fund HRDF. The HRDF is a pool of funds that consists of human resource development levy computed by the employers. The monthly HRDF computation must be reported and paid before the last day of the next month. The amount of levy that employer should pay is based on the slide, the table there. So, as my research, employer who pay HRDF are actually good. That is, they can apply to HRDF for various government grant to train the employees. So this is the slide have shown the hyperlink. You all can click to get more information about sleep art. Okay, this is all from us. Thank you for your time to hear our presentation until end.